Welcome back to Protecting Trade Secrets. I'm Professor Seth C. Oranburg. In Module 3, we explored risk, uncertainty, and valuation, how to assess threats, quantify vulnerabilities, and determine what trade secrets are worth. We learned that effective protection requires both analytics and judgment because you can measure some risks but not all uncertainties. Now, in Module 4, we shift from assessment to action. We're moving from identifying vulnerabilities to mitigating them. And the most important place to start is with the people who have access to your secrets: employees, contractors, and other insiders. This module focuses on internal risk mitigation, the policies, protocols, and cultural practices that prevent trade secrets from walking out the door. Over the next 3 lectures, we'll cover employee confidentiality agreements, joiner mover leaver protocols, and training and enforcement strategies. In this first lecture, we focus on contracts, specifically employee confidentiality agreements that actually work. We'll explore why agreements fail when tested in litigation, what courts demand to find them enforceable, and how to draft provisions that balance employer protection with employee rights. We'll address consideration requirements, scope and duration limits, the mandatory DTSA whistleblower notice, and the strategic relationship between non-disclosure agreements, non-competition agreements, and non-solicitation agreements. By the end, you'll understand that a confidentiality agreement is not just a piece of paper you collect at onboarding. It's a foundational element of your trade secret protection plan, and if it's drafted carelessly, it can undermine your entire case. Let's start with why employee confidentiality agreements fail to realize legal protections. Here's the uncomfortable truth. Many employee confidentiality agreements are not worth the paper they're printed on. They fail for predictable reasons. They use language that's too broad or too vague. They apply the same boilerplate terms to every employee, regardless of role or access. They're signed once, at onboarding, and never mentioned again. And when litigation arises, courts look at these agreements with skepticism because they suspect the company didn't take its own secrets seriously. Let me give you a concrete example. In nClosures, Incorporated versus Block & Company, a 2014 Seventh Circuit case, nClosures sued a former manufacturing partner for trade secret misappropriation. nClosures argued that it had shared confidential product designs, drawings for a custom metal tablet case, under an implied understanding of confidentiality. The problem? There was no signed NDA. The drawings weren't marked as confidential. There were no access restrictions. No documented security protocols. When the case reached the Seventh Circuit, the court dismissed the claim. The reasoning was blunt. Trade secret protection requires more than hope. It requires structure. The court emphasized that confidentiality agreements serve a critical function. They provide notice. They tell recipients that the information is confidential, that they have obligations, and that violations will have consequences. Without that notice, documented, clear, and specific, courts won't enforce trade secret rights. But even having an NDA isn't enough if it's poorly drafted. Consider Great Hill Equity Partners versus SIG Growth Equity Fund, a 2018 Delaware Chancery case. The buyer of a tech company claimed that the seller's use of business information violated their NDA. The agreement defined confidential information to include virtually all company data, regardless of whether it was public, private, or already known to the receiving party. The court refused to enforce it. Why? Because the definition was so broad it became meaningless. If everything is confidential, then nothing is confidential. The court found the language unreasonably overbroad and declined to give it effect. These cases illustrate a critical principle. Courts reward precision and punish overreach. They expect confidentiality agreements to be specific, grounded in reality, and proportionate to the information they're protecting. When agreements fail those tests, courts treat them as evidence that the company didn't take its own secrets seriously. So what makes an agreement enforceable? Let's break it down by the key doctrinal requirements. Every contract requires consideration, something of value exchanged by both parties. For confidentiality agreements, this requirement creates practical complications, especially in at-will employment states. When an employee is hired, there's typically no problem. The job offer itself, The promise of employment serves as consideration for the employee's promise to keep information confidential. Courts routinely uphold non-disclosure agreements signed at the start of employment because both sides are giving up something. The employer is offering a job, and the employee is agreeing to confidentiality obligations. But what happens when you ask a current employee to sign a new or updated confidentiality agreement? In at-will employment states, where either party can terminate the relationship at any time for any lawful reason, courts are divided on whether continued employment alone constitutes sufficient consideration. Some jurisdictions hold that continued employment is adequate consideration. The logic is straightforward. The employee gets to keep their job, and the employer gets additional protections. Both sides benefit, so the contract is enforceable. Other jurisdictions reject that reasoning. They argue that in at-will employment, the employer could terminate the employee at any time, so continued employment isn't really a benefit because it could end tomorrow. These courts require additional consideration: a raise, a promotion, a bonus, access to new information, or some other tangible benefit beyond merely keeping the job you already have. This creates a strategic problem for employers. If you roll out a new confidentiality policy and require all employees to sign updated agreements, but you don't provide additional consideration, you may find that those agreements are unenforceable in certain states. The safest approach? Provide some form of additional consideration whenever possible. It doesn't have to be substantial. A modest signing bonus, a small raise, access to training, or even a one-time payment can suffice. What matters is that the employee receives something they didn't already have. Alternatively, time the signing of confidentiality agreements to moments when consideration is clear: promotions, role changes, access to new projects, or participation in sensitive initiatives. At those moments, the employee is receiving a benefit, and the agreement becomes part of that exchange. The consideration doctrine also intersects with timing. If an employee signs an NDA after they have already gained access to confidential information, courts may question whether there was a valid exchange. The better practice is to require signature before disclosure, so the agreement is prospective, not retroactive. The second major enforceability issue is scope. What information does the agreement actually cover? Courts demand precision. They want to see definitions that are specific enough to guide behavior, but broad enough to capture the information that actually matters. Striking that balance is harder than it sounds. Many agreements define confidential information as all information disclosed by the company. That's too broad. It sweeps in public information, general industry knowledge, and things the employee already knew before they were hired. Courts will narrow or strike down such definitions because they don't meaningfully separate what's secret from what's not. A better approach is to use layered definitions. Start with general categories: technical data, business strategies, customer information, financial projections, and then add context-based qualifiers. For example, consider this language. Confidential information means information that 1. Is marked as confidential, proprietary, or trade secret at the time of disclosure, or 2. Would reasonably be understood to be confidential based on its nature and the circumstances of disclosure, including but not limited to. And then the confidentiality agreement goes on to list concrete categories, for example, source code and algorithms, design documents and specifications, financials, pricing and margins, product roadmaps and launch plans, customer and prospect lists and usage data, test and evaluation results, including what didn't work, security and operations materials like network diagrams and access controls, contract terms and ongoing negotiations, and combinations or compilations of otherwise public items where the selection or arrangement isn't generally known. Now, here's what actually matters about that list and what a court will look for. First, it has to track the elements of a trade secret. The information must have real economic value because it isn't generally known, and you must take reasonable steps to keep it secret. So your list should point to valuable technical or commercial material, and you should be able to show markings, access limits, and NDAs. Second, cover compilations and negative know-how, but be specific. Courts protect unique combinations and the secret integration of known pieces. Don't just say proprietary combinations, name them. And failed experiments can count as negative information, so identify them clearly, like failed formulations or tuning that didn't work. Third, acknowledge lawful, proper means, independent development, and reverse engineering are generally proper under trade secret law. You can forbid reverse engineering of what you deliver under the contract, but you can't turn public facts into secrets. So keep the standard carve-outs alongside your list. Fourth, cover all forms and derivatives, and fix the oral disclosure problem. Say it includes information in any form, plus notes, summaries, and models. If something is disclosed orally or visually, identify it as confidential on the spot and follow up quickly in writing. That helps prove reasonable measures. Finally, set sensible duration and handle compelled disclosure. Trade secrets last as long as they remain trade secrets. For other confidential information, use a reasonable fixed term. Add notice and protective order language for subpoenas, and include the DTSA whistleblower-immunity notice elsewhere in the agreement. Being measured makes the clause more enforceable, not weaker. This language combines objective markers, labeling with subjective understanding context. It narrows the scope to information that the recipient knew or should have known was confidential, which is the standard courts apply when evaluating misappropriation claims. Scope also involves temporal limits. How long does the confidentiality obligation last? For information that qualifies as a trade secret under law, the obligation should be indefinite, lasting as long as the information remains secret. This aligns with the legal definition. Trade secrets are protected as long as they meet the three-element test, and that protection doesn't expire like a patent. But for information that doesn't qualify as a trade secret, routine business information, strategic plans that will become public, or market data with a short shelf life, a time limit is appropriate. Many agreements specify that general confidential information must be protected for 2 to 5 years after disclosure, but trade secrets must be protected indefinitely. This distinction matters in litigation. If you claim that information is a trade secret, but your NDA only required confidentiality for 2 years, opposing counsel will argue that you didn't really treat it as a trade secret. You treated it as temporary business information. The contract signals what you actually valued. Scope also includes carve-outs, explicit exceptions to the confidentiality obligation. The most common carve-outs are information that was already known to the recipient before disclosure, information that becomes publicly available through no fault of the recipient, information lawfully obtained from a third party without confidentiality restrictions, information independently developed by the recipient without reference to the company's disclosures. These carve-outs are standard and reasonable. They prevent the agreement from claiming ownership over information the company never actually contributed. Courts expect to see them, and their absence can make an agreement look overreaching. Finally, scope should be role-specific. A senior engineer with access to source code needs a different agreement than a sales rep with access to customer lists. The language should reflect the actual information the employee will encounter and the risks associated with their position. Generic, one-size-fits-all agreements signal that the company didn't think carefully about what it was protecting. In 2016, Congress passed the Defend Trade Secrets Act, the first federal civil cause of action for trade secret misappropriation. The DTSA created powerful new remedies, including ex parte seizure orders in extraordinary circumstances, but it also imposed a new requirement on employers, the whistleblower-immunity notice. Under Section 1833, subsection B, individuals cannot be held criminally or civilly liable under federal or state trade secret law for disclosing a trade secret to government officials or attorneys if the disclosure is made in confidence and for the purpose of reporting or investigating a suspected legal violation. This provision protects whistleblowers. It ensures that employees can report fraud, safety violations, or other misconduct without fear that the company will retaliate by accusing them of trade secret theft. But here's the catch. If an employer wants to enforce trade secret rights under the DTSA, and if those rights involve a contract or policy entered into or updated after May 11, 2016, the employer must provide notice of this immunity to employees. Specifically, the notice must inform employees that they are immune from liability if they disclose trade secrets in confidence to government officials or attorneys for the purpose of reporting suspected violations of law. The statute provides safe harbor language that employers can use verbatim to satisfy this requirement. If you include the prescribed notice in your confidentiality agreement or employee handbook, you're in compliance. If you don't, you lose the right to seek exemplary damages and attorney's fees under the DTSA, even if you win your case. That's a significant penalty. Exemplary damages can be up to twice the amount of actual damages, and attorney's fees in trade, secret litigation, can run into the millions. Failing to include a 3-paragraph notice can cost you those remedies. The notice should be placed prominently in confidentiality agreements, employee handbooks, and any policy document that addresses trade secrets. It should be clear, conspicuous, and unambiguous. Many companies include it as a standalone section titled Notice of Immunity under the Defend Trade Secrets Act. Here's the key language, taken directly from the statute. An individual shall not be held criminally or civilly liable under any federal or state trade secret law for the disclosure of a trade secret that A is made in confidence to a federal, state, or local government official, either directly or indirectly, or to an attorney, and I, solely for the purpose of reporting or investigating a suspected violation of law, or B is made in a complaint or other document filed in a lawsuit or other proceeding, if such filing is made under seal. This notice does not weaken your trade secret protections. It does not give employees free rein to disclose information. It simply acknowledges what the law already provides, that whistleblowing in good faith, conducted through proper channels, is protected. What it does do is make your DTSA claims enforceable and preserve your ability to seek enhanced remedies when misappropriation occurs. Confidentiality agreements don't exist in isolation. They often appear alongside, or within, broader restrictive covenants, non-compete clauses, non-solicitation provisions, and invention assignment agreements. The relationship between these clauses is strategic, not mechanical. Each serves a different function, and courts evaluate them under different standards. A confidentiality clause restricts the use and disclosure of information. It protects the secrecy of knowledge by prohibiting the employee from sharing it or using it for unauthorized purposes. Courts generally favor these clauses because they align with the core purpose of trade secret law, preventing wrongful disclosure. A non-compete clause restricts the employee's ability to work for competitors or start a competing business. It doesn't focus on information, it focuses on activity. Courts view non-competes with skepticism because they restrain worker mobility and limit competition. Many states refuse to enforce them at all. Others enforce them only if they're narrowly tailored in scope, duration, and geography. A non-solicitation clause prohibits the employee from soliciting the company's customers, clients, or other employees. It's narrower than a non-compete. It doesn't prevent the employee from working for a competitor, only from targeting specific relationships. Courts are more willing to enforce non-solicitation clauses than non-competes, especially when the clause is limited to customers the employee actually worked with. Here's the strategic insight. Confidentiality agreements are foundational. Even if a non-compete is unenforceable in your jurisdiction, a well-drafted confidentiality agreement can still prevent the employee from using or disclosing your trade secrets. And in jurisdictions that allow limited non-competes or non-solicitation clauses, those provisions can provide additional layers of protection, stopping not just disclosure, but also the competitive conduct that makes disclosure valuable. The key is to draft each clause independently, so that if one fails, the others survive. Courts use severability doctrines to strike down overbroad provisions without invalidating the entire agreement, but only if the clauses are functionally separate. For example, if your confidentiality clause is enforceable, but your non-compete is struck down as overbroad, you still have protection against disclosure. If your non-solicitation clause survives, but your invention assignment provision is narrowed, you can still prevent the employee from targeting your customers. This modular approach also helps in negotiation. Employees and their counsel often push back hard against non-competes, but they're more willing to accept confidentiality and non-solicitation provisions. By separating the clauses, you can negotiate strategically, preserving the protections that matter most while showing flexibility on the provisions that are less central to your trade secret strategy. Let's recap. Most employee confidentiality agreements fail because they're too broad, too vague, or not supported by adequate consideration. Courts demand precision, context, and evidence that the company took its own secrets seriously. Consideration is essential, especially when asking current employees to sign new agreements. Provide additional value whenever possible: a raise, a promotion, a bonus, or access to new opportunities. Tie signing to moments when the exchange is clear. Scope must be specific and layered. Define confidential information with both objective markers and contextual qualifiers. Distinguish between trade secrets, which must be protected indefinitely, and general confidential information, which can have time limits. Include standard carve-outs and tailor language to the employee's role. The DTSA whistleblower immunity notice is mandatory for agreements entered into or updated after May 11, 2016. Include the safe harbor language prominently to preserve your right to seek exemplary damages and attorney's fees under federal law. Finally, integrate confidentiality clauses with non-competes and non-solicitation provisions strategically. Draft each clause independently so they can survive or fail separately. Focus on enforceability, not just strength of language. In our next lecture, we'll turn to the Joiner Mover Leaver Protocol, the operational framework for managing trade secret risk at the 3 highest risk moments in the employee lifecycle: when they join, when they move internally, and when they leave. We'll explore what documents to collect, what access to grant and revoke, and how to structure exit interviews that actually protect your secrets. Thanks for listening. See you in the next lecture.